Hello, Chamber members, and welcome to our latest informational session. My name is Mike Payon. I'm with the Joliet Chamber, as most of you probably know. Today we have with us Andres Mendez, and Andres is a benefits advisor with the United States Department of Labor in the Employee Benefits Security Administration section. And today we're going to talk about COBRA, the various health benefits, and touch upon as well a new premium subsidy that has come out as part of the American Rescue Plan Act. So we're excited to have Andres with us today and his information that he brings with, as this is very important to all of our businesses, current and future chamber members. So with that said, hello, Andres. Welcome. Thanks for being with us. And I will turn the screen over and let you fill us in on all of this pertinent information.
Thank you for the introduction, Mike. And as Mike mentioned, I will be going over COBRA and other pertinent laws, or more specifically, the American Rescue Plan Act, which has had huge implications for both employers and employees. So many employees and their families will lose group health coverage because of life or work events. And obviously, they're able to continue their coverage under their employer's group health plan for limited periods of time. And so the first thing that we'll be addressing is COBRA, the law itself. COBRA amended ERISA, which is the Employee Retirement Income Security Act of 1974. It's probably the most well-known employee benefits law, certainly the largest and one of the most complex areas of law in general. It also amended the Internal Revenue Code and the Public Service Act to require most group health plans to provide temporary continuation of group health coverage that would otherwise be terminated. And so what is COBRA continuation coverage? COBRA requires group health plans to offer continuation coverage to qualified beneficiaries, such as covered employees, former employees, spouses, former spouses, dependent children, when the group health coverage would otherwise be lost due to specified events. These are known as qualifying events. These events include the death of a covered employee, termination or reduction in hours of a covered employee's employment for reasons other than gross misconduct. Gross misconduct being some kind of really egregious action, like stealing something on the job or putting a coworker's life in danger, things like that. If this ever becomes a question of whether something constitutes gross misconduct, we could definitely have that conversation, and I'll be providing our contact info at the end of the presentation. This would also include, so other reasons why a person would be entitled to COBRA continuation coverage would be the covered employees becoming entitled to Medicare, divorce or legal separation of a covered employee and a spouse, or a child's loss of dependent status under the plan. This really refers to the Affordable Care Act about children being allowed to stay on their parents' plan till age 26. A little bit more about that coming up. And so we'll get into each of these requirements in the following slides. Okay, so who is entitled to COBRA? An individual will be entitled to COBRA if these three following requirements are met. Number one, if the group health plan is subject to COBRA. Number two, a qualifying event occurs. And then number three, obviously, if they're a qualified beneficiary. So is your health plan subject to COBRA? The answer would be yes, if it's a group health plan, which is going to be the case for almost every employer out there that I could think of. If it's sponsored by a private sector employer, again, this agency, the Employee Benefits Security Administration, we deal with private employers, so that's right up this chamber's alley. With regards to government, just really quick, there are different laws that govern that realm, and we wouldn't necessarily have jurisdiction, though we could always point people to the right place. And then the last point would be those businesses that employed at least 20 employees in the previous calendar year. Notice that caveat, it's in the last calendar year. So if this ever becomes an issue, we always just review the records of the employer. The employers generally provide them. Not really a big, this doesn't really come into play that often, though I'm sure there are some niche situations where this might be a factor. plan coverage. So under COBRA, a group health plan is any arrangement that an employer establishes or maintains to provide employees or their families with medical care. Whether that is provided through insurance, by a health maintenance organization, out of the employer's assets, on a pay as you go basis or otherwise. So medical care for this purposes includes things like inpatient and outpatient hospital care, physical care or physician care, I'm sorry, surgery and other medical benefits, prescription drugs, dental and vision care, the things that we usually associate with our health plan. Life insurance for these purposes is not considered medical care, nor are disability benefits. So COBRA does not apply to these benefits. Again, COBRA does not apply to life insurance or disability benefits. Group health plans are subject to COBRA, or group health plans subject to COBRA are sponsored by private employers generally, and welfare plans governed by ERISA. So again, ERISA, Employee Retirement Income Security Act. Under ERISA, group health plans must be administered by a plan administrator who is usually named in the plan document. This is typically an officer of the company. If it's a small company, it's probably going to be the owner. Many group health plans are administered by the employer that sponsors the plan, but group health plans are frequently administered in whole or in part by an individual or organization separate from the employer, such as a professional business administration firm, third-party administrators, basically. Sometimes companies relegate HR tasks to third parties, and that's perfectly fine. That's all well and good under ERISA. But that's the important thing to know, is that administration of the plan is typically something that's coordinated with the employer and with other third parties. Carrying out the requirements of COBRA is a direct responsibility of the plan administrator. So again, all the parties involved are liable, or are they're required to comply with COBRA, ERISA, other existing employee benefits laws. Plans that meet the requirements to be a qualified small employer, HRA, are considered to be exempt from ERISA and COBRA. And if we have any questions about that specifically, we can address that as well. So plan coverage sponsored by an employer. COBRA generally applies to all group health plans maintained by private sector employers with at least 20 employees, or by state and local governments. The COBRA provisions of the Public Health Service Act covering state and local government plans are administered by the Department of Health and Human Services. An important thing to know specifically for this state, for the state of Illinois, since this is the Joliet area Chamber of Commerce industry, is that Illinois does also have its own continuation laws. They usually refer to it as mini COBRA. It's basically just meant to catch blind spots of the existing federal law. And so for Illinois, employers that are covered under mini COBRA, which is either the public sector or employers with less than 20 employees, they also have to provide the premium, because Illinois mini COBRA is basically mirroring already existing federal COBRA. Special rules may apply to multi-employer plans. This includes qualifying events and election notices. For our discussion, we will be speaking about private sector single employer plans. We won't be speaking about multi-employer plans. Federal government health plans may be subject to similar provisions, exactly like I mentioned. The law does not apply, however, to plans sponsored by the federal government, churches, or certain church-related organizations. Plan coverage. COBRA applies to employers with at least 20 employees on 50% of their typical business day in the previous calendar year. Both full and part-time employees are counted to determine whether the plan is subject to COBRA. Each part-time employee counts as a fraction of a full-time employee. It's pretty self-explanatory, with a fraction equal to the number of hours that the part-time employee worked divided by hours an employee must work to be considered full-time. If that ever becomes an issue, we'll address it on a case-by-case basis. Who is entitled to COBRA? So remember, the important thing to remember here is that they have to meet these three requirements. If you're missing any of these three, not a COBRA beneficiary. So again, your group health plan must be subject to COBRA. This includes group health plans sponsored by private sector employers with 20 employees or more in the previous calendar year. qualifying event must occur. And again, we mentioned those are things like, loss of employment, so terminations, reduction in hours, divorces, things like that. So we will talk about qualifying events next. So what is a qualifying event? Qualifying events are those that cause an individual to lose his or her group health coverage. The type of qualifying event determines who the qualified beneficiaries are for that event and the period of time that the plan must offer COBRA continuation coverage for. COBRA establishes only the minimum requirements for continuation coverage. A plan must always choose or may always choose to provide longer periods of coverage. So just because the law says, for example, that the employer is required to offer at least 18 months of continuation coverage, that's not to say that if the employer is extremely generous, which doesn't that's up to each business. If the employer is extremely generous, they can offer the participant the option of staying on the plan for however long as they like or however long is practicable. We just mentioned that because that question comes up sometimes, but just know that there are minimums set by existing federal law. So continuing qualifying events. The following are qualifying events for employees if they cause the covered employee to lose coverage. So these would include termination of the employee's employment for any reason other than gross misconduct or reduction in hours of employment. Okay. Continuing qualifying events. The following are qualifying events for the spouse and the dependent child if a covered employee if they cause the spouse or dependent child to lose coverage. So this includes termination of a covered employee's employment for any reason other than gross misconduct, reduction in hours worked by the covered employee if the covered employee becomes entitled to Medicare. Again, becoming entitled to Medicare spells the end of group-sponsored health coverage for a lot of employees. If there is a divorce or legal separation of the spouse from the covered employee, or if there is the death of the covered employee. In addition to the above, the following is a qualifying event for children of a covered employee if it causes them to lose coverage. So that would be loss of dependent child status under the plan's rules. That's going to be age 26 after the American Rescue Plan Act. An enumerated event that does not result in loss of coverage will not constitute a qualifying event. So if an individual has a reduction in hours but retains group health plan coverage, there is no qualifying event. We could talk now about the third requirement that is needed for an individual to be entitled to COBRA. This has to do with qualified beneficiaries. So a qualified beneficiary is simply an individual who was covered by a group health plan on the day before the qualifying event occurred that caused him to lose health coverage. So again, the day prior to experiencing the event. Only certain individuals can become qualified beneficiaries due to a qualifying event, and the type of qualifying event determines who can become a qualified beneficiary when it happens. So a qualified beneficiary must be a covered employee, the employee's spouse or former spouse, or the employee's dependent child. In certain cases involving bankruptcy, the bankruptcy of the employer sponsoring the plan, a retired employee's spouse or former spouse, and the retired employee's dependent children may be qualified beneficiaries. Again, these are fringe cases that are best discussed on a case-by-case basis. In addition to any child born to or placed for adoption with the covered employee during the period of COBRA coverage is automatically considered a qualified beneficiary. Agents, independent contractors, and directors who participate in any group health plan may also be qualified beneficiaries. So now that we've looked at the three requirements, we know if an individual is entitled to COBRA continuation coverage. So we can see how long those benefits should be provided for. So notice procedures. A group health plan must provide covered employees and their families with certain notices explaining their COBRA rights. These plans must also have rules for how COBRA is offered, how qualified beneficiaries go about electing COBRA, and also when coverage can be terminated or will be terminated. These rules are currently affected by our disaster and relief guidance, which we will discuss after these main slides. So the summary plan description, or sometimes referred to as a summary of benefits, it really just depends on which employer you talk to. This document, the summary plan description of the group health plan, must describe COBRA continuation coverage rights provided under the plan. This is pretty standardized language that is probably going to be included in the paperwork provided to employers by the third party that's likely going to handle sending these notices out. But just know that that's a requirement for employers who decide to sponsor health plans. All participants must receive a summary plan description from the group health plan within 90 days of becoming a participant in that plan, or within 120 days of the plan first becoming subject to the reporting and disclosure requirements under ERISA. The summary plan description is part of the disclosure requirements of ERISA. This is, if you want to get really boring, it's part 1, sections 102 and 104B, rather than the COBRA provisions of part 6. The summary plan description is a written document that gives important information about the plan, including what benefits are available under the plan, so basically what's covered, and the rights of the participants and beneficiaries under that plan. It's generally a document that describes in very boring detail how the plan works and the rules under the plan, both for participants and for the employer. The COBRA General Notice, this is the document, this is the important part to note. The COBRA General Notice, or known as the Model Notice, is basically what group health plans must give to each employee or each spouse who becomes a covered, a qualified beneficiary under COBRA. The General Notice must be provided within 90 days of cover. Oh, this is, yeah, COBRA General Notice, coverage notice. Okay, so basically the disclosure of healthcare coverage materials has to happen within 90 days. Plans can satisfy this requirement by including the general notice in the plan summary plan description. Okay, so I guess that's a way to really for the employers to cover themselves. The general notice should contain information that an individual needs to know during their COBRA, or during the time that they become a COBRA qualifying beneficiary. And so I guess by disclosing this at the beginning when they first become covered under the plan, that's enough under the law. The general notice must include the name of the plan, the address for the plan, telephone number of someone whom the employee can contact for more information on COBRA or on the plan in general. It has to have a general description of the continuation coverage period under the plan, an explanation of what qualified beneficiaries have to do when they find themselves in that situation, an explanation of the importance of keeping the plan administrator informed of any address changes. This is something where unfortunately participants, they sometimes fail to notify the former employer of the fact that they changed their address, and the employer makes a good attempt to find them, but if they can't, unfortunately the employee is not going to get crucial information. So it's important to stress this to employees that if they're terminating service with the company, or if they're leaving or anything like that, that they need to make the company aware of the fact that they moved, so that the company can fulfill its requirements under the law. A statement that the general notice does not fully describe COBRA or that the plan will provide more complete information, when the qualifying event happens. The model general notice, the Department of Labor actually has developed a model general notice that single employer group health plans can use to satisfy general notice requirements. It's available on our website, which is www.dol.gov/agencies/EVSA. I can provide all those links at the end. So in order to use this model federal notice properly, the plan administrator must complete it by filling in the blanks with the appropriate plan information. Okay, so COBRA qualifying events continued. COBRA qualifying event notices. Before a group health plan must offer COBRA coverage, the qualifying event must occur, and the plan must be notified of the qualifying event. Who must give notice of the qualifying event if it occurs? The employer must notify the plan, and when we say the plan, that includes not only, well, the employer is clearly aware of the fact that this is occurring, but if there is a third party that's going to be sending out these notices on your behalf, like the WageWorks of the world, different companies like that, they need to also be aware of this. And so the employer must notify the plan if the qualifying event is, again, termination, reduction in hours, death of a covered employee, bankruptcy of the employer, covered employee becoming entitled to Medicare, et cetera. The plan has, or the employer has 30 days to notify whatever third party is also going to be involved in this process. And with regards to the covered employee or one of the qualified beneficiaries, so this is not from the employer side, but rather from the employee side or their dependents. Those qualified beneficiaries have to notify the plan if there's a divorce, if there's a legal separation, or if one of their children is losing coverage under the plan, is losing their dependent status under the plan because they turned 26. Group health coverage plans are required to have procedures for how the covered employee or one of their qualified beneficiaries can provide notice of these types of qualifying events. These procedures should be described in both the general notice and the plan documents, the summary plan description. If procedures give covered employees and qualified beneficiaries at least 60 days after the qualifying event occurs to give notice, and the procedures must describe how and to whom notices should be given and what information must be included in the qualifying event notice. If one person gives notice of a qualifying event, the notice of all qualified beneficiaries affected by that notice must occur as well. If a group health plan does not have reasonable procedures for how to give notice of a qualifying event, the qualified beneficiaries are permitted to give notice to the person or unit that handles the employer's benefit matters, probably going to be HR. If a plan is administered by an insurance company, notice can be given to the insurance company. Continuing with the COBRA election notice, after receiving the notice of a qualifying event, the employer must provide qualified beneficiaries with an election notice, which describes their rights to continuation coverage and how to make that election. So the election notice must provide the qualified beneficiaries, or must be provided to qualified beneficiaries within 14 days after the plan administrator receives notice of a qualifying event. So what this basically boils down to is that both the employer and the third parties, whoever's involved in getting this information out to participants, they have 44 days in total, 30 for the employer to notify the third party, 14 days for the third party to actually send out the notice to the participant. So 44 days in total. I think that that's really much more simple, for our purposes. What must the election notice include? It has to include the name of the plan and the name, address, telephone number of the plan's COBRA administrator. It has to identify the qualifying event. It has to identify the qualified beneficiaries by name or by status. An explanation of the qualified beneficiaries' rights to elect COBRA. The date coverage will terminate if COBRA is not elected, how to elect COBRA, what will happen if continuation coverage is elected or waived, which participants do have the right to waive coverage. Say, I don't want to continue coverage under COBRA. What continuation coverage is available for how long, how COBRA might terminate early, premium payment requirements, the statement of the importance of keeping the plan administrator informed of address changes, and a statement that the election notice does not fully describe COBRA and that more information can be found in the summary plan description. We also provide these model election notices on our website. And again, I will provide the link at the end of the presentation. COBRA notice of unavailability of continuation coverage. So if a group health plan is denying COBRA or an extension of COBRA when the plan determines that the requester is not entitled to receive it, there are certain requirements for that as well. And so the notice must be provided within 14 days after the request is received, and the notice must explain the reason why the request is being denied. COBRA notice of early termination of coverage. So COBRA coverage must generally be made available for a maximum period of either 18 months, 29 months, or 36 months. It's almost always going to be 18 in most circumstances. The group health plan may terminate COBRA earlier, however, for any number of specific reasons. When a plan decides to terminate COBRA early for any reason, the plan must give a qualified beneficiary a notice of early termination. The notice must be given as soon as practicable after the decision is made, and it must describe the date coverage will end, the reason for termination, and any rights that the qualified beneficiary has, to either appeal this decision or to convert a policy into an individual policy. So we could talk about election procedures as well. COBRA requires that group health plans provide qualified beneficiaries an election period during which they can decide whether or not to elect COBRA. At a minimum, each qualified beneficiary must be given at least 60 days. So this is key as well. After receiving the COBRA election notice, the participant has 60 days to elect whether or not they want to continue coverage under COBRA. So with regards to, how to keep track of the dates, right? So at a minimum, like I said, each qualified beneficiary must be given 60 days to choose whether or not they want to continue coverage under COBRA. Beginning from the later of the date the election notice is either provided, or the date on which the qualified beneficiary would otherwise lose coverage under the group health plan due to the qualifying event. Each qualified beneficiary must be given an independent right to elect COBRA. What does this mean? This simply means that if, for example, there's the employee, his or her spouse, and their children, each of those has the ability to either elect or waive COBRA. So for example, if there is someone in the family who really needs to stay on the health plan for some illness or some kind of health concern, you could keep one of the people on without keeping everyone else on. And the reason for this is very easy. COBRA continuation coverage is very expensive, and were it not for the American Rescue Plan Act, the majority of people do not continue coverage under COBRA, the majority of terminated employees. So the plan must allow a covered employee and the covered employee spouse to choose on behalf of qualified beneficiaries. That's pretty understandable. This has to do with legal guardianship over a minor child. If a qualified beneficiary waives COBRA during the election period, the qualified beneficiary must be permitted to later revoke that waiver if they're still within their election period. So to simplify this, since the participant has 60 days to elect whether or not they want to continue coverage under COBRA, if on day one they immediately say, oh no, I don't want to continue coverage under COBRA, they waive their right to COBRA. However, if within that 60-day period they come back and they say, okay, I didn't consider this at first, but now I did, and I need coverage under the plan, if they're still within that 60-day election timeframe, they can rescind their waiver of COBRA. Next slide. This has to do with the duration of continuation coverage. So in almost every case, I don't think I really need to go into all that detail for this. If there's ever a question with regards to how long continuation coverage should last, I encourage you to reach out to our agency. We have 8 benefits advisors in our office in Chicago, though you could theoretically speak to anyone across the country. It's almost always going to be 18 months for most employees, their spouse or dependent children. This is for termination or reduction in hours. And so the reason that the 36 months that you see on the slide are very rare are because they are these very niche situations. So just to go over a few of the rare instances, and again, it's very rare that someone actually gets 36 months of continuation coverage. The first reason would be that the employee becomes entitled to Medicare. So if the person turns 65, they're entitled to Medicare. The spouse and the dependent children would be able to continue coverage under that plan given certain circumstances. If there's a divorce or a legal separation, the spouse and again the dependent children can get the 36 months. If there's the death of a covered employee, same thing as above. The loss of a dependent child status, again occurring at age 26, that would certainly allow the dependent child to become eligible for COBRA, and that's 36 months beginning with the loss of that dependent child status. There is also the disability extension. That would be the asterisk at the bottom of the page. So if a person is declared or determined disabled by the Social Security Administration, again, very important, the person has to basically provide the employer the letter, the determination letter. If they're determined to be disabled within the first 60 days of their COBRA continuation coverage period, which this includes retroactive determinations, right? The person could be determined to have been disabled during that time. They get 11 months for a total of 29 months. So again, if you find yourself in this situation, there's some guidance that we provide as well, but you're more than welcome to talk to one of our advisors. Extension of COBRA coverage. If a qualified beneficiary is entitled to an 18-month maximum period of COBRA, they may be eligible for an extension in two circumstances. Like I said, the first is when a qualified beneficiary is disabled. Kind of already covered this on the previous page, but again, just know that that would be 29 months if they are actually able to provide that letter, that determination letter from Social Security, within the time frame allotted by the rules of the plan, which is, they have to have been determined disabled within the first 60 days of commencing that. The 11-month extension is available if a qualified beneficiary, again, is determined either by the Social Security Administration to have been disabled at some point before the 60th day of COBRA coverage, and the qualified beneficiary notifies the plan administrator of that determination. The extension must be provided not only to the disabled qualified beneficiary, but to any family member who is a qualified beneficiary in connection with the same qualifying event. The plan can set a time limit for providing this notice of disability, but the time limit cannot end before 60 days after the latest of either the date on which Social Security issues that determination, the date on which the qualifying event occurs, the date on which qualified beneficiary loses coverage under the plan as a result of a qualifying event, or the date on which the qualified beneficiary is furnished the COBRA general notice or summary plan description. However, the plan may require notice, get rid of that. The plan may require notice of disability to be provided before the end of the first 18 months of COBRA continuation coverage. This is common under a lot of plans. A lot of plans just say, if you notify us about the fact that you were determined disabled before your 18 months end, that's fine. But that's really at the discretion of the plan administrators who design the plan. But just know that a lot of plan documents include this as standard language. The right to a disability extension may be determined or may be terminated if the SSA, so the Social Security Administration, determines that the qualified beneficiary is no longer disabled. So pretty self-explanatory. If the person is able to return to work, the extension is over. The plan should describe in its summary plan description and in the election notice of any offer of COBRA coverage with the maximum period or with a maximum duration of less than 36 months, how a notice of disability determination or notice that the qualified beneficiary is no longer disabled should be provided to the plan. Okay. Second, qualifying events. Again, we already kind of went over them, but just know this could include death of a covered employee, divorce or legal separation from a covered employee and spouse, loss of dependent child status, again, age 26, or the covered employee becoming entitled to Medicare. Won't go too much into that anymore. We've kind of like beating a dead horse. Early termination of COBRA. So the group health plan may terminate COBRA earlier than the end of the maximum period for the participant, which again is probably 18 months, 29 or 36, for the following reasons. So if the health plan is terminated and there's no longer a health option being offered because the company may be closed or went bankrupt, there is no COBRA coverage available. If there's no plan, there's no COBRA continuation coverage for that plan. However, if another plan is offered by the company, the participant may be covered under that plan. Again, these are really specific cases. Don't need to get too much into these. COBRA can be terminated early if a qualified beneficiary engages in conduct that would justify the plan in terminating coverage of a similarly situated participant or beneficiary not receiving continuation coverage. To note this last bullet point, which is that certain types of conduct that a qualified beneficiary could engage in, such as fraud, obviously that's reason to terminate COBRA early for someone. If COBRA is terminated early, the plan must provide the qualified beneficiary with an early termination notice. COBRA has standards for continuation coverage that must be provided. The coverage given must be identical to the coverage that is currently available under the plan to similarly situated active employees. What this basically boils down to is that there can't be any sort of discrimination between what is offered to current active employees and people who are on COBRA. Easy examples of this is that if something is covered under the plan, like let's say visits are covered at, I don't know, 80%, right, for a participant, a visit to the doctor, the people who are continuing under COBRA cannot be made to pay a higher cost than people who are actively on the plan. Or for example, if it comes time for open enrollment, end of the year, and current active employees are allowed to pick and choose, maybe I want medical, but I don't want dental and vision, or I want medical and dental, but I don't want vision. If those choices are allowed, the people who are on COBRA also have to be allowed to make those decisions. So again, this includes co-payments, deductibles, coverage limits. The qualified beneficiary must comply with the rules of the plan. So this applies to benefit claims and appeals processes, which are all time-sensitive things that people have to do with quite a high frequency, actually. Who pays for COBRA? So under normal circumstances, the participant is the one who is responsible for the cost of COBRA premiums. So the plan is limited to charging the participant 102% of the premiums. Why is it 102%? Because the participant can be made responsible for 100% of the COBRA premium costs, because the law only mandates that employers offer continuation coverage. They don't mandate that the employer actually pay for it. And the 2% is what is allowed to be charged as an administrative fee for keeping the person on the plan. So this right here is the reason why under normal circumstances, most participants choose not to continue coverage under COBRA unless they can afford it, or maybe if there's some kind of extenuating circumstance. Plans must allow qualified beneficiaries at least 45 days from COBRA election to make their initial premium payment. There's almost always a grace period, but just know that there's a minimum of 45 days that the participant, the qualified beneficiary, has to have after their election to satisfy that premium. Must be given a minimum 30-day grace period for payment of any premium. Again, so in reality, it turns out to realistically be 75 days in most circumstances, well, at least for the initial premium. And then after that, since payments occur on a monthly basis, typically on the first day of the month, then the person has a 30-day grace period to make those payments. Pretty generous, depending on point of view. COVID-19 relief. So here is the huge caveat with regards to COBRA. Very important to talk about this. This is probably the most popular topic of discussion right now with us and with the people who call in. So the Employee Benefits Security Administration issued a joint notice with the Department of Treasury and the Internal Revenue Service, the IRS, that extends certain timeframes for employee benefit plans due to the COVID-19 pandemic, which is clearly still raging. With the beginning of the declared national emergency, which is on March 1st of 2020, until 60 days after the announcement of the end of the COVID-19 national emergency, which has not been announced yet, this will be referred to as the outbreak period. The relief provides participants and beneficiaries in group health plans additional time to comply with certain deadlines for requesting special enrollment in a group health plan, the COBRA election period, the COBRA premium due dates, claims for benefits, and special enrollment periods. Group health plans, disability, and other employee welfare benefit plans subject to ERISA must disregard the outbreak period for all plan participants, beneficiaries, qualified beneficiaries, or claimants located in determining or when determining certain periods or dates. So really what this means is that these laws affected the deadlines that people have to take certain steps for continuing their coverage under COBRA. So the extensions give participants and beneficiaries more time to make important decisions about their health coverage and decisions affecting their benefits during the coronavirus outbreak. The joint notice also provides relief to group health plans with respect to the provision of the COBRA election notice. In addition to the relief provided by the joint notice, the department separately announced that the Employee Benefit Security Administration, again, our agency, that the disaster relief notice 2020-01, this provides an extension for deadlines of furnishing COBRA election notices. So what all this means practically is that we're not going to, for example, a company's not going to get in trouble if they were late by a day or two in furnishing these notices, because we understand that with the whole pandemic, there's obviously a lot of people being laid off, a lot of people experiencing qualifying events, and also that some companies are short-staffed. So particularly with regards to like smaller employers, we're not going to be as stringent in these deadlines, but we'll give a little bit of leeway is essentially what we're saying. The Employee Benefit Security Administration Disaster Relief Notice 2021-01 provides guidance on the duration of the COVID-19 related relief. And then, for more information, of course, we encourage you to visit our coronavirus webpage, which I will provide the links to at the end. So COBRA as it relates to the American Rescue Plan Act, or ARP, so I don't have to keep saying American Rescue Plan Act the whole presentation. Qualified beneficiaries who are assistance eligible individuals, otherwise referred to as AEIs, will pay 0% of their COBRA premiums during the assistance period. So next question, when is the assistance period? So this started on April the 1st and will run through September 30th, 2021. Premiums will be reimbursed to the employer, the plan, or the insurer via a payroll tax credit. This includes a second election period called an extended election period, which is basically just a second opportunity for people to elect COBRA who may not have elected it at first when they saw the huge premium costs, right? So like people, that's usually what turns people away immediately. So assistance eligible individuals, just really quick. So who is an assistance eligible individual under the American Rescue Plan Act? This would, so under these provisions, qualified beneficiaries who are assistance eligible individuals would pay no premiums for the COBRA coverage during the assistance period. The COBRA premium subsidy is for coverage periods beginning on April 1st, continuing to September 30th, 2021. Let's see here, kind of repeats itself. The COBRA premium subsidy is available for assistance eligible individuals. So an assistance eligible individual is a qualified beneficiary who, as a result of an involuntary termination, so this is the key part, or a reduction in hours, is eligible for COBRA continuation coverage during the assistance period and who elects to continue coverage under COBRA. Qualified beneficiaries can be or can include the employee, the spouse, and or the dependent. If the employee's termination of employment was for gross misconduct, the employee and any dependents generally would not qualify for COBRA or the subsidy. So again, gross misconduct makes you ineligible for all this. The premium subsidy duration. So the premium subsidy is generally available between April the 1st, 2021 and the earliest of September 30th, 2021. The end of the qualified beneficiary's maximum COBRA continuation coverage period, or the first date an assistance eligible individual becomes eligible for other group health plans. So basically, how can this status of an assistance eligible individual, the premium subsidy, how could it end early? If the person finds another job and becomes eligible to go under another company's plan, that's the end of the subsidy. If they're exhausting their COBRA continuation coverage period, which is the 18 months. So like if they went on COBRA well over a year ago, their 18th month is coming up during the middle of the subsidy period. There's no extension, unfortunately. That's it for them. A little more detail on eligibility for other coverage. As noted, the assistance eligible individual, if they lose eligibility for the subsidy, when they become eligible for other group health coverage, such as a new employer's plan or a spouse's plan, they have options for continuing coverage as well. Clearly through a new employer, they could just go on the new employer's plan, or there's also options available in the marketplace, which if anyone finds one of their employees in that situation, you could refer them to our agency. Extended election period for assistance eligible individuals who became eligible to elect COBRA before April 2021. Individuals can enroll, in their company's coverage again. If the person became eligible before April 1st of 2021, they have one of two options, really. They could either pick up their coverage April the 1st and go forward, taking advantage of the subsidy, or they could go back to their original COBRA start date. However, they would have to pay up until April the 1st, and then they would continue with the subsidy until the subsidy is over. So again, second opportunity for participants who maybe didn't elect when they first became eligible due to a variety of circumstances, usually the cost. Extended election period continued. Assistance eligible individuals who didn't elect COBRA when it was first offered, or who elected it and then discontinued it, have a second opportunity if the period for which they would have COBRA continuation coverage has not expired. So again, something to watch for, the 18 months or the 29 or 36. Extended election period. A plan must provide an assistance eligible individual with notice about the extended election period. This is the general notice. There is one that employers can get off of our website and use for their own purposes. You just have to tweak the language somewhat, and perfectly fine. We recommend that you do that, and that's actually, we've noticed, what most employers are doing. Assistance eligible individuals can elect up to 60 days after the notice is provided. COBRA coverage begins the first period of coverage beginning on or after April 1st, 2021. Under the extended election, coverage is not retroactive to periods before enactment. So what does that mean? It just means that a person is not going to get the subsidy for anything before April the 1st. A lot of people are going to ask that. The answer is no. Coverage is the same maximum duration that the qualified beneficiary would have had if elected when first offered. The general notice. So the American Rescue Plan Act includes 3 notices that the plans must provide to assistance eligible individuals. One is the notice we just discussed, the notice about extended election periods. Key information about the American Rescue Plan Act is provided by the plan in the general notice, which we will now discuss. So unless specifically modified by the American Rescue Plan Act, the existing COBRA notice manner and timing requirements continue to apply. Employers may be subject to an excise tax by the IRS if they fail to provide this documentation. General notice. The general notice is to provide qualified beneficiaries with information on the premium subsidy and their rights under ARP, the American Rescue Plan Act. So qualified beneficiaries, not just the covered employees, that also includes their spouses or dependents. It must say who are the qualified beneficiaries as the result of an involuntary termination of employment, a reduction in hours, and those who became entitled to elect COBRA coverage at any time during the assistance period, April the 1st through September 30th, 2021. The alternate notice, this is for assistance eligible individuals to whom the election notice requirements don't apply. So for example, for plans subject to state continuation coverage, mini COBRA. So this would probably not apply to most employers here. Notice contents, this is really information that you could review on your own if you like, but it just basically comes down to forms necessary to establish eligibility for the subsidy, descriptions of who a qualified beneficiary is, description of the election period, description of the option for the qualified beneficiary to enroll in different coverage. Pretty straightforward. Extended election period notice. This is just basically letting people know that when they have until to make a decision with regards to their continuation under the plan. Just as it says on the slide here, plans must send notice of extended election periods to any assistance eligible individual or any individual who would become an assistance eligible individual if COBRA continuation coverage were in effect, who became entitled to elect COBRA coverage before April the 1st. This does not include individuals whose maximum COBRA coverage period would have ended before April the 1st. More continued here. Plans must notify AEIs in writing 45 to 15 days before the expiration of the premium assistance. That's probably the most important thing on this slide. So the point of this is that the various federal agencies who had a hand in drafting this legislation, they want participants to understand clearly when this subsidy ends. So 45 to 15 days before September 30th, there has to be a notice that goes out to participants letting them know that the subsidy will end and that they have options under the Affordable Care Act marketplace, and or if they found a new job, etc. Medicaid is another example that's state sponsored. Model notices. So here is the link. HTTPS, so www.dol.gov/COBRA-subsidy. And I will provide this to an email. I will provide this to you, Mike, in an email so you could share it with the various members of the chamber. Tax mechanics, tax treatment for individuals. This basically is a little complex. You'll probably want to consult if you're a business with a tax professional, but the subsidy received is not taxable income to the qualified beneficiary. For employers, the planner issuer, the COBRA costs are covered by a tax credit. So that's the way that the government is essentially making this work, is that the employer pays for it on the front end and they get a tax credit for doing so. Tax penalty for individuals. If an AEI fails to notify the plan of eligibility for other coverage, they may be subject to a tax penalty of $250. So this includes lying by omission. So like if an employee doesn't let the company know that, hey, I got another job and I'm eligible for their plan, this would apply to them. If it's an intentional failure, it could be the greater of $250 or 110% of the premium assistance received after no longer eligible. There's a reasonable exception. So no penalty if the failure was due to reasonable cause or not willful neglect. Coordination with health coverage tax credit. So the health coverage tax credit provides certain eligible individuals with the 72.5% of their health insurance premiums. This is administered by the IRS. Of course, if we receive any questions that we're unable to answer here, we can always get you in touch with someone over there at the IRS. Assistance eligible individuals cannot utilize HCTC in any month in which they receive the COBRA subsidy under the American Rescue Plan Act. It's probably the most important part of this particular slide. And we're almost done here. Alternatives to COBRA. When losing group health coverage, an individual should consider COBRA and all the other options available to them. So this includes a special enrollment in a health plan. This is typically for a spouse. So again, this is key because under the American Rescue Plan Act, if you're eligible for a spouse or to be under a spouse's plan, you don't qualify for the subsidy. The health insurance marketplace set up by the Affordable Care Act, state-sponsored plans like Medicaid, and then Medicare if that's becoming a factor. Again, key, if the person is entitled to Medicare, they're not a qualified or an assistance eligible individual, I should say. The role of the federal government in COBRA. So obviously the U.S. Department of Labor and the U.S. Department of the Treasury have jurisdiction over private sector group health plans. So we oversee disclosures, notices, eligibility, coverage, and then any laws requirements regarding payment. So coordinating with other federal benefit laws, obviously the FMLA, Family Medical Leave Act, HIPAA, Health Insurance Portability, and Accountability Act, that includes special enrollment rights. USERRA, all these laws clearly still in effect, not really affected by the passing of the American Rescue Plan Act. So for more resources, obviously that's our webpage regarding the COBRA premium subsidy that you're more than welcome to visit. Has very useful publications and/or model notices for employers to use. Other than that, we can always provide publications on request if you need us to send some to your business. I will include these in an email to you, Mike, for you to share with your members. But other than that, that's really all I have. I don't know if there are any questions. Feel free to. You could go through Mike or whoever there at the Joliet Chamber of Commerce, or you could contact us directly at our offices at EBSA Chicago.
Well, thanks, Andres. That was certainly a wealth of information.
Definitely.
And certainly something that can be used by all companies.
Mhm.
I know there are some size requirements, but
Yeah.
especially for our companies on the smaller side that
Mhm.
don't necessarily have an HR department, this is certainly useful
Mhm.
information and something that I know can be utilized in various aspects with a wide range of companies. So thank you again for being with us today, and again for sharing this information.
Yeah.
And we'll look forward to circling back around and potentially offering some other
Yeah.
categories and topics to cover in the future.
Yeah,
But for
certainly.
today, this was great information, again, that can certainly be
Mhm. Yeah,
utilized by
just really
a
quick.
good number of our members.
Yeah, just really quick. Thought this would be useful. This is our website, EBSA. You could probably just type in on Google EBSA and it'll come up, and then there's a big blue button on the side here where it says COBRA Premium Subsidy. You click on Learn More, and then here you can find, frequently asked questions. The model notices are all available here for employers to download and edit. So just I really like this. Really user friendly, and then that's really all I had to share. Okay, so Mike, I will send you an email with these publications and links, and then you could do with them what you will, or disseminate them to whoever needs more guidance or information.
Well, thank you. And thanks again, Andres, for your time today. We greatly appreciate it. And yeah, chamber members can certainly always reach us at 815-727-5371. And we can help with this information and any other information going down the road. So thanks again, everyone. Hope you're doing well and prospering. And we'll catch up with you soon. Take care.
Yep. Thank you. Have a good day.